Good morning, everyone. This is Keith Eastland. I'm with Miller Johnson's employment section, and my friend and partner, Larry Tabin, is going to be with us this morning. We are in the spring break week version of our COVID-19 morning updates, so happy spring break week to everyone. At least we did have some sunshine in the last day or so that's good news. But the reality is we continue to be in tough times, challenging times, restless times for many at home, and frankly, frustrating times trying to figure out all the different laws and executive orders that have been going on, being passed, as well as just managing employees and business operations during these difficult times. You may have seen that Michigan, the number of cases is continuing to increase. As of last night, we noted that there were 18,970 confirmed cases of COVID-19 with the terrible news of 845 total deaths. And so that's weighing heavy on many of our hearts, I'm sure, all of our hearts, I'm sure. But we did get a little bit of good news locally. Spectrum Health President and CEO Tina Fries-Decker gave a statement last night. You may have seen it on the news, but basically Spectrum is saying, look, the efforts of social distancing and other things that we are doing is projecting to be working. And they're estimating that it may have flattened the curve up to 65%. So some really great news locally in terms of what we've been doing as a community. And that's I guess, a bit of good news. And hopefully as we move forward the next few weeks, we'll hear even better things. So what is today's topic? Today's topic is going to be the at-risk individuals under the executive order that was issued by Governor Whitmer on last Friday, and that's Executive Order 2020-36. And this is the order that directs at-risk or particularly at-risk individuals to stay home even if they could work. So I'm going to cover some of the basics on what the order does and instructs for people who meet the at-risk requirements. And then I'm going to turn it over to Mary to talk about the employment protections that are provided by this executive order. And then we're kind of pass it back and forth as we get into a number of different things. And I think what will be very important for many of you on the call today is how does this interact with unemployment, for instance? How does this executive order interact with the Families First Corona Response Act and the paid sick leave or FMLA components of that? And so we're going to get into some of that, and then we're going to finish up with some examples that we think may help walk you through some of the issues that you may have questions on, or some of you may have already encountered these examples. So let's start with the basics. What does this executive order do? Well, it does two things. First, it tells individuals who are at particular risk of spreading COVID-19, you need to stay home. So even if you could work, even if you have, you're part of an essential workforce and you need to go make critical infrastructure parts for ventilators, whatever it may be, this says you should stay home even if you could work. And then secondarily, for those people who are at risk and who do stay home, it creates employment protections so that they won't necessarily lose their job, and then they may, under certain circumstances, be entitled to paid leave. And working from home, trying to get the slides to advance, just bear with me. There we go. Okay, so who is at particular risk? And the way I view this is there's two groups, right? First, you have the individuals who test positive or who display at least one symptom. So that's me personally, the individual, the employee. I either test positive or I have one of the principal symptoms, one or more. The second group is if I'm in a household, let's say my spouse or my children have symptoms or test positive. Now I'm in close contact with a person who tests positive. So you have the two groups. And I think that's important to understand those two groups. I mean, they're easy to understand, but they matter for purposes as we go through what the executive order really does. So you say the obvious question is, okay, what is a principal symptom? It's easy if you get a positive test. Everybody understands that. What are the principal symptoms? The executive order defines them as three. One is a fever, two is an atypical cough, and three is an atypical shortness of breath. If you're asking me what atypical means, I don't know. I think it means atypical in terms of what you would normally get. Maybe if you have seasonal allergies and you have a little nasal drip and you have a cough, you know what that feels like. If you have a general cold, maybe you know what that cough feels like. It's atypical, I think, maybe if it's maybe inside, lower in the chest, that sort of thing. But it's really a function of atypical for that individual because there's no guidance that the executive order gives. With respect to fever, there is no set number in the executive order, no temperature. But I do know that the CDC has issued guidance that says it's 100.4 is the number to use. But if employee says, hey, I have a fever for, 99.4 or whatever, and I usually run a little low, maybe you're like Chris Cuomo. If you've been following any of that, he's been around 99, 100, he said, but he runs low. Hey, that's a fever. And I think that's going to be covered under the executive order. Okay. And so what does close contact mean, right? It doesn't mean that I rode up in the elevator with somebody when I was on my way to the office to get some important paperwork so I can telework. No, it means being within approximately 6 feet of a person for a prolonged period of time. And so, we're talking about, more than 5 minutes, more than 15 minutes probably. Clearly, this is going to be somebody in your household that you're around a lot of the time, but it could be if you have meetings and you spend 30, 40 minutes at a time with somebody. That could also likely mean close contact. Okay, so those are the two groups. That's the protections. Those are the people that, not the protections, but those are the people that need to stay home under the order. Okay, well, how long should these individuals and your employees potentially stay home? Well, if they're directly impacted, the executive order says that you need to stay home 3 days after your symptoms have resolved and 7 days after their symptoms first appeared or since they were swabbed for the resulting in a positive test. And of course, if you get a negative test, then you can return. You don't have to stay at home if you get a negative test. So it's 3 days after symptoms resolved and at least 7 days after their symptoms first appeared. So that period is going to be at least 7 days, right? And that assumes your symptoms resolve within that 7-day period. Likely could be 10 days easily, especially if I say, well, you know what, I've had, or longer, right? If I have a fever and an atypical shortness of breath, and that lasts for a week, okay, my symptoms haven't resolved, so I got to wait 3 days after they resolve, and then 7 days from the time my symptoms first appeared. You got to meet both there. Okay, and you can see how this could result in some prolonged periods of absence. The second is if you're in close contact. Here, this is more, I think, more of a concern in terms of a rolling period of having to stay at home. You've got to stay at home until 14 days have passed since your last contact with an at-risk person. So, for instance, if my spouse had the symptoms and she had them for 11 days, well, if I've been in the home teleworking with her for the last, for all those days, that's 11 days. Now I have to wait 14 more days. So I'm in contact and I got to wait 14. Now you're looking at 25 days. So you could see how that could really, really add up. Okay, I'm going to hand it over now to Mary because you guys don't want to hear just one person talk, and I think that it's always good to get a different perspective. But she's going to run you through what the employment protections are under the executive order before we get into some of the interactions with all the other fun laws that everyone's dealing with. Go ahead, Mary.
Thanks, Keith. Good morning, everyone. I'm going to walk you through a few slides regarding what those types of employees that Keith just described in Group 1 and Group 2, what kind of employment protections they have if they are allowed to work because they are deemed a critical infrastructure employee, or they are a basic minimum employee that must come into work, but they are not allowed to under this executive order because they are at risk. So there are several protections that as employers we want to be very conscious of. The first one is that we cannot discharge, discipline, or retaliate against an at-risk employee for staying home for the periods that Keith just described. So if we think of our EEOC statements that we all have in our handbooks, that we can't discriminate or retaliate against for protected categories such as sex, race, religion, we all are very familiar with those. Some policies say, or public policy, we want to insert this in there in our minds. I'm not suggesting you revise your handbook, certainly for this pandemic, but we want to think of this executive order as being another protected category that's an exception to the at-will employment. So, of course, after the period ends, you can discipline or discharge an employee if they refuse to come to work. Now, that is easier said than done, and we have some hypotheticals at the end of this presentation that shows just how difficult that is sometimes to know when the executive order has ended and when you can force someone to come back to work and when you can't. The other protection is we cannot take an adverse action for an employee's failure to comply with a requirement to document, and this is a very broad protection. So again, it's an employee's failure to comply with a requirement to document that the employee or the individual with whom the employee has had a close contact has one or more of the principal symptoms of COVID-19. So before, when we are getting our arms around the FFCRA and the documents that we need for that, we were obviously requesting and requiring documentation so that we could make sure we had good internal documentation as well as preventing fraud. And this broadens that for sure and wraps another protection around the employee, that this protection now is very employee controlled, and the employees have the control of whether they should be staying home or not. And then with the next slide, Keith, if you could, thank you. Employees at risk must also be treated as taking a medical leave under Michigan's Paid Medical Leave Act. So in our world, we still think Michigan's Paid Medical Leave Act is a new law, but as we have entered into this new pandemic world, that seems like an old law, and even some of these prior executive orders that were issued in March, such as unemployment, seems old now. And in reality, these are all still new laws. So we want to treat that at risk for taking leave the same as a medical leave under Michigan's Paid Medical Leave Act. So if the employee has exhausted paid leave under the MPMLA or it does not apply, the leave can be unpaid. And now this is where our employers seem to fall into two buckets. One that would not want their leave to be unpaid and would want to either provide them with additional paid leave under their policy, or even have done enhanced policies because they want their employees to stay home if they're not feeling well. Those employers are in one bucket, and then we have another set of employers that really need their workforce to show up, and they are they're monitoring these leaves very closely, and they would want those leaves to be unpaid and hopefully not paid by unemployment to encourage folks to show up. They're in healthcare industry or whatnot, and they really need folks to come to work. Employers are permitted but not required to reduce hours from an employee's accrued leave during the time, and the leave continues for the duration of the stay-home periods under the executive order. So that's another provision to highlight, is that the employee's leave under this Executive Order 36 does not end when the Michigan Paid Leave Act would end, or when there are other, paid time off or other leave that an employer has. It goes with the symptoms of the employee or the directive of the executive order. So what employers are covered? And again, this executive order is very broad. One of the broadest that we have seen, and it seems to go with the theme that these executive orders will continue to be issued if we do not flatten the curve, because they want folks to stay home if they're remotely ill or close to anyone that has exhibited symptoms. So employers of all sizes, no exception for small employers or large employers. So for those of us who are thinking about the other laws that have passed, such as the FFCRA that exempts 500 or more, or has that alleged small business exception of 50 employees or less, that does not apply here. Nothing in our world where we think of the MMPLA or the regular FMLA that has a 50 employee threshold. That all should not be confused with this order. There is no exception for the size of the employer. And if you employ a Group 1 individual, now those are the individuals, remember, that they themselves are impacted. So they either have a positive test or they have one of those COVID-19 symptoms that Keith went through. There are no exclusions. So if you are healthcare or other institutions that have been largely exempted from different executive orders or laws that have been passed, if you employ Group 1, you are subject to this executive order. There are some exclusions for Group 2. Now remember, Group 2 are not the individual himself, but that employee has come in close contact with someone. But those exclusions are very narrow. There's just a few, and we've listed those on the slide: healthcare professionals, doctors, nurses, those types of positions, workers at a healthcare facility as defined by the executive order, and that's not as broad as you may think. First responders, child protective service employees, workers at child care institutions, and workers at correctional facilities. So words on an executive order matter. It's interesting that they made a clarification that there's some exclusions for workers at child caring institutions instead of having a broader application, for example, adult foster care. That seems to not have made one of the exclusions for Group 2 in a host of other institutions and employers that are caring for vulnerable individuals. And with that, I'm going to turn it back over to Keith to talk about the impact on employees and employers.
All right. Thanks, Mary. And that's an interesting point that Mary raised there about how the Group 1 folks do not get the coverage. And, I think from a healthcare perspective, my guess is, healthcare facilities, they're already doing that, right? You don't want somebody coming in to work to treat folks or be around patients if they're displaying symptoms, that sort of thing. But I do find it interesting to remember, because even if you're in those excluded groups, correctional facilities, for instance, if, a corrections officer decided, I have a symptom, then they would be subject to that EO. And so I think that is an important distinction to remember. Just because if your organization if you're confident that they're excluded, they're only really excluded from that Group 2, not that Group 1. And you need to think about how you're going to handle situations for anybody in that first group. So what does this all mean for employers, right? So sum it up maybe for us, and then we'll get into the details. This is my take. This gives tremendous control to the employee. The employee is going to determine whether they need to stay home. The employee is going to tell you whether they have a fever. They're going to tell you whether they have an atypical shortness of breath or an atypical cough. And there's not really a whole lot you're going to be able to do about it, right? And what does that create? Now, certainly I'm not suggesting that people are going to, everyone's going to lie about this. I hope that's not the case. In fact, my guess is many of you have great workforces where 90% of your people are going to use this the right way to make sure that this thing isn't spread, and that's a great thing. But we have to account for the potential for abuse. It will exist. And this may be especially important for those folks in critical manufacturing that, they're struggling to keep people working, especially with unemployment and all the things available to everyone. There's a sense, I think, publicly of, well, wait a second, I don't want to work. Why do I have to work? And if people catch wind that they can say, hey, I have a fever and an atypical cough, or they can claim that, hey, my spouse has those things and her symptoms have gone on for a week, so I need to miss 21 days, 7 days for her symptoms and 14 days because that's what the executive order says. And those potential, consecutive periods could add up. I mean, where's the end? Okay, well, I had it, the symptoms. You didn't get tested. No, I stayed at home. I self-quarantined. I had symptoms. Then I gave it to my wife, my kids, and so on. Now we have 4 people in our family, and it all took a week. So now we're at 4 weeks, plus we all have to stay in our house for 14 more days. Just think of that consecutive periods if somebody really wanted to play that game. Hopefully that won't be the case, but this is a reality that you have to be prepared to deal with. And the critical component of this is the executive order says you cannot take adverse action if they refuse to document their need to stay at home. So, and technically it's the need, it's to document symptoms, right? That's what the executive order actually says. And so there's no way for you to make me show you that I had an atypical cough. You have to take my word for it. Okay. So that's where we see this. And then the real question is, well, how does this interact with unemployment, FFCRA, other issues, and then we'll get into some enforcement issues down the road. Because I think it does matter, right? Because, if you're off on this executive order, stay at home, leave status, okay, I'm sick, I've got the symptoms, or I test positive. Then the question is, do I get leave? Well, I would if I have any leave in my, and I'm covered by the Michigan Paid Medical Leave Act, I might get paid leave. But it's a separate question whether I'm entitled to unemployment benefits or it's a separate question if I'm entitled to paid sick leave under the FFCRA. And so you're going to have a lot of overlap. And I think it's important to remember that you got to look at each one of those specifically. And each one has its own set of rules and its own set of eligibility requirements, and you have to march through each one. And so we're going to talk a little bit about the interaction between these statutes and executive orders to kind of bring a little bit, hopefully more clarity to how this is going to play out in your world. And then we'll talk a little bit about enforcement. So I'm going to talk about unemployment interaction issues, and then I'm going to hand it off to Mary to talk about the FFCRA interaction. Okay, so let's back up on unemployment. If you've been tracking this, which many of you have or are tracking, there was Executive Order 2020-24 that Governor Whitmer issued that expanded unemployment eligibility, okay? And part of that was this quote here under this sub-bullet point was, you know, for purposes of the able, available, and seeking work requirements, suitable work is unavailable because of COVID, which satisfies the requirements of Section 28 for all claimants. What does that mean? That means that I don't, if there's a COVID reason, generally under unemployment, the able, available, and seeking work requirements won't apply. So you say to me, what does that really mean? Does that mean an employee can refuse suitable essential work? I don't think it does. I think it means that I don't have to be able and available and seeking work, but if I am able and I have a job and I turn down suitable work, we think there is at least an argument there. And granted, we don't know what the unemployment agency is going to do with this, but we still think there's an argument there separate from this new executive order that you're refusing suitable work and you shouldn't be qualified for unemployment benefits. And the reason we've taken that position with many clients and we think that argument exists is because for some clients, they could lose people for unemployment, and if they're eligible, they can get up to $962 a week when you add in the extra $600 per week that the Federal CARES Act is making available, and that's through July 31st of this year. Some people are going to make as much or more potentially on unemployment. So they just say, well, I'm not coming to work. And then it becomes critical whether they're entitled to unemployment benefits. So we think that there's an argument that if they refuse suitable essential work, that you could still argue that they're not eligible for unemployment. Okay. But what about this new EO? What does that mean for all of this? Well, on the next slide, I'm going to talk about, we're going to compare the reasons for the stay-at-home order and the reasons for unemployment. But then I do want to say one thing about challenging unemployment. We got this question from a few people. It's like the executive order says you cannot retaliate against an employee who stays at home. And remember, that's what you cannot retaliate or take adverse action for, is they're staying at home. That's the protected conduct. So if they stay at home and they file for unemployment and you challenge that, is that retaliation? We don't think so. I think anytime you're taking a good faith, honest position that, hey, we don't think you're eligible, and you report the facts and the truth to a state agency, that's not retaliation. That's just application of the law. But let's take a look at the different reasons for unemployment. When you line them up side by side, the expanded reasons that you can get unemployment under Executive Order 24, as well as the reasons you can stay home, right? So if you look at the first one for staying home under the new executive order, it's if I test positive. If I test positive for COVID-19, that is not on one of the reasons for eligible expanded unemployment. Now, that puts us in the case of, well, if I test positive, will I get unemployment? Well, am I refusing suitable work? Probably not refusing it. I'm not able to do it. And so then I think you might get it because of that general statement that I read from the earlier slide. Okay, what about the next one? If I'm displaying at least one principal symptom, absolutely. There's direct overlap there. So if I'm at home and I'm delaying one, and I'm displaying, one principal symptom, that's displaying the symptoms of COVID, and that's a reason I'm going to get unemployment benefits under the expanded state executive order. Okay, what about the last one? The last reason for staying at home under the new executive order. I've had close contact with a person who tested positive or who has the symptoms. Okay, I don't see that on the right column, right? You don't see it there. Is it a need to care for someone with a confirmed diagnosis? Maybe, maybe not. It depends on the facts, right? Just having close contact with my spouse doesn't mean I need to care for her, and it doesn't mean that she's got a confirmed diagnosis. And so that one doesn't apply. Having contact in the last 14 days with someone with a confirmed diagnosis. Again, I may have had contact with my spouse and she may have symptoms, but is there a confirmed diagnosis? So I think if the reason is the third reason for staying at home on the left side of the column, on the left column, I think you may have an argument that, hey, you're not entitled to unemployment. And so that's going to depend on the facts. All that being said, I think practically, we're in the weeds a little bit. And you have to step back and say, okay, who's deciding this? This is going to be decided by the unemployment agency, and what's likely going to happen? They're likely going to get the benefits. Now, but I do also think practically there's a deterrent for understanding when folks are eligible for unemployment and when they're not, especially if you need people to work so that they understand whether they're entitled to those benefits or not. And so if I call up and I say, hey, I need to take time off because my wife's got symptoms of COVID-19, I have to stay at home under the executive order, I think if you wanted to, you can honestly say, I don't think you get unemployment. I think you need to understand that. Now, certainly you need to stay home if this is all true, but we want to make sure the employee understands what the truth is. Now, whether you challenge that or not, obviously that's up to you. You don't have to, and a lot of people won't. But I just wanted to go through that interaction here with everyone on the unemployment side of things. With that, I'm going to flip it back to Mary to talk about the interaction with the FFCRA.
Thanks, Keith. And yeah, as you pointed out, lots of gray area continues regarding these conflicting laws and different tests. So now how do we treat this new Executive 36 with the FFCRA, which we're all still getting our arms around as the Department of Labor continues to issue new regs and new guidance on those, it seems, daily or weekly. So interaction with the FFCRA, remember the reasons for emergency paid sick leave regarding that act is unable to work and need leave because the employee is subject to federal, state, or local quarantine or isolation order, and we will come back to that, has been advised by a healthcare provider to self-quarantine. The emphasis there is has been advised by a health provider. FFCRA is not employee-driven. It's more medical-driven with the standard medical documentation and advice that we are used to when we administer other laws such as ADA and FMLA. 3, the employee is eligible for FFCRA if they experience symptoms similar to what Keith had talked about, the fever, the coughing, the shortness of breath, but again, and is seeking a medical diagnosis. So under the FFCRA, it continues to tie in the medical documentation and the healthcare professional's opinion. And then number 4 reason is caring for an individual subject to quarantine or isolation order or who was advised by a health provider to self-quarantine. So if any of those apply to the employee that is telling you that they need leave, you can still secure information and documentation needed to grant the federal leave. Same for the emergency family medical leave. So I want to pause there because we have the Executive Order 36 that says, well, you can't retaliate against someone for failing to provide medical documentation. So first, again, words matter in these executive orders, and it says retaliate for failing to provide documentation. Even under the Executive Order 36, you can still ask for it. You can still even require it. You just can't take adverse action or discipline or discharge under Rule 30 or Executive Order 36. But under the FFCRA, and these are laws that we will want to keep separate and distinct, if they are seeking for payment under this for taking a leave, you can still secure and require information and documentation as listed in the FFCRA. You want to do that if you're an employer thinking that you want tax credit for that leave. You'll want to have still good documentation for that. And two, you'll want documentation to comply with their requirements. But one thing to note is we have not been paying much attention to the first qualification for an employee to get FFCRA paid leave, which is if the employee is subject to a federal, state, or local quarantine or isolation order until recently, because our executive orders have been increasingly beyond the encouraging to stay home to mandating staying home. And so we believe the new executive order is a state quarantine or isolation order that may trigger the paid emergency sick leave, and documentation is likely going to be that order itself. And we will be going through some hypotheticals here shortly that shows you exactly how that works. All right, and then with the next slide, we have Keith, I'm not quite seeing that. Yep, thank you. So lawsuits for violating the executive order. So what kind of trouble can we as employers get in if we mishandle a leave under the executive order? So the order on its face makes clear that there is no private right of action. So what does that mean? An employee can't go and file a lawsuit against us. So while that is good news, there are still some more heavy-handed penalties in this. So they are going to enforce violations the same as they do under the Michigan Paid Leave Act. And in addition to that, they are going to, so there will be, under the Michigan Paid Leave Act, there is LARA enforcement. So if you are an employer that has licensing, they can certainly, under this executive order for a violation, remove your licensing, and there are also fines in place in the thousands of dollars regarding violation of this order. In addition, if we go to the next slide, the state has been taking a very aggressive stance with this order, almost simultaneous with issuing the executive order. We found on the state's website this very, what we see as anti-employer education piece. Now, while we applaud the state for educating employees about their rights, usually they are more even-handed with employer-employee. But on the state website, it says how to file a MIOSHA complaint against your employer. And of course, when we look at the heading, employers can't retaliate against workers for taking time away from work under these circumstances. So they are certainly having a flow chart that talks through everything that Keith and I worked through with you this morning. And you will notice when they are talking about the symptoms in the lower right corner, they have removed the atypical cough or atypical shortness of breath. Not that we talk like that in the normal world anyway, and we can't expect our employees to have read the executive order and use the magic words atypical or atypical shortness of breath or cough, but that will at times require additional follow-up from you regarding whether they do have those symptoms or they're experiencing other symptoms that are not COVID-19. All right, I think that we are going to head into our first hypothetical here. So I drafted this first example, and I wasn't that creative, so I just used my co-presenter's name for the hypothetical. So Keith works for Eastland Manufacturing as a machine operator. Eastland Manufacturing is a critical infrastructure supplier, and Keith has been designated as a critical employee needed to physically perform work at the facility. Okay, so we have an employer that is operating under the executive order lawfully, the prior one that allows for critical infrastructure entities to continue to work. But as we have been seeing, as time has gone on and increased testing and data that shows that we still have a lot to go in getting past this pandemic, more and more of the employees for our employers are getting concerned and are asking additional questions. And so in this hypothetical, we have morale is not great at the plant. We have seen in real life employees becoming more and more questioning the sanitary efforts and just their need to return to work when their friends, neighbors, family members are not. So just pausing there to make sure you continue to keep your communication up regarding why you are still operating and the need to still operate and the importance of the employee and their work that they do for you, and certainly continue to communicate and show the increased sanitary efforts. So in this hypothetical, again, morale is not great. Keith calls the attendance line and says that over the weekend he spiked a fever and is not breathing very well. He called his doctor, who told him stay home for 7 days. Keith wants to know if he will get paid. He has previously exhausted all of his all of his PTO. So let's first go through and think, okay, he's asking for paid time off. So under the FFCRA benefits, would he get benefits? Under this hypothetical, we believe he would. He has at least one symptom, maybe two. You know, his one symptom is that he has a fever. He didn't say he has an atypical shortness of breath, but he did say he has a shortness of breath, and so you would want to ask a couple questions of this employee regarding that aspect of it. But note here that he has sought treatment. Remember, the doctor said that he needs to stay home. So he would be getting that FFCRA. And so assuming that you have less than 500 employees and the FFCRA would pay for this leave. In addition, what about the Executive Order 36. Now, remember when we talked about how this could be and should be seen as a self-quarantine. So even though you could ask under the FFCRA for medical documentation, the fact that they are staying home and they have told you that they have a symptom that falls under the Executive Order 36, that executive order could and should be the only document you need to provide FFCRA benefits, because he falls into a couple categories here for FFRCA payment. And then UIA benefits. Let's say that Keith's symptoms continue. He needs to stay beyond the paid leave under the FFCRA or any paid leave that you provide. Under this scenario, he would likely get UIA benefits because he is experiencing those symptoms, and going back to Keith's chart, that is a direct overlay. And remember that he gets leave until 3 days after his symptoms resolve. So even though this hypothetical is for 7 days, as we all know, if you've been following the British Prime Minister, who is currently in the hospital with COVID-19, he had symptoms for 10 days and then worsened and then required going into the hospital. So some folks seem to get over this virus very quickly. Others, it lingers for a lot longer. So with that, Keith, do you have anything to add regarding this example?
Yeah, I would just say as a practical matter on the unemployment benefits, yes, he's having symptoms, and that's a qualifying reason for unemployment benefits. But remember, if Keith decides that he's going to, apply for paid leave and get that, well, then that paid leave is going to, wipe out his eligibility, because he's going to have to report his earnings to Marvin, and so practically he wouldn't. He could apply for unemployment and get it, but he wouldn't get a weekly benefit. So if you wanted to help employees in Keith's situation, and I encourage helping Keith's out, that's good. That's a good thing. But if you want to help them, you would tell them, well, don't apply for unemployment benefits yet until after your 10 days of paid sick leave are exhausted, because remember, your payment is going to reduce your benefit amount. And generally speaking, if you earn more than 1.5 times your weekly unemployment benefit amount, then you're going to be phased out. And that's done on a state level. And if you're phased out of that, you would get zero in any week because you got earnings. You also wouldn't get the $600. So just practically keep that in mind. And then also remember that even if Keith wasn't eligible for the 2 reasons Mary explained for the FFCRA leave, he still might have PTO or paid medical leave under the Michigan statute. And if he does, and I'm off for a Executive Order 36 reason, staying at home, then I can use my Michigan paid leave as well under the state law for that reason. I think there was a question I saw earlier, and I think that answers that. So let's move on to example 2. So same scenario, but then Keith calls in 7 days later and reports, hey, I got my test and it's negative. That's fantastic. Everybody's happy. So you say, Mary tells Keith, hey, time to come to work. And I say, well, wait a second. I don't really want to come back to work because now my wife's got an atypical cough. What do you do? And can you ask for medical confirmation? Well, can we ask for medical confirmation? Well, you guys remember the slides from before? Well, we can certainly ask for confirmation or documentation from Keith that his wife has this, but if we ask, we can't do anything about it. We can't take any adverse employment action because Keith doesn't provide it. So Keith's still going to be able to stay at home and be put on leave per the Executive Order 36. Okay, what about this scenario though? So I've been cleared. I have a negative test. Now, do I get FFCRA? Well, go through the reasons. I'm not subject, or am I subject to a local quarantine or isolation order? Actually, I am. And the reason that I am is because I'm in close contact with my spouse, who under Executive Order 36, the government in Michigan is telling me I have to stay isolated. And therefore, that is a reason one under the emergency paid sick leave under FFCRA. So I think you would be entitled to it if I hadn't exhausted my 10 days. Remember, it's only 10 days. What about FMLA under FFCRA? That's an important consideration too. Remember that the FFCRA has two components, right? Emergency sick leave, which has 5 specific reasons and 1 additional catch-all that hasn't been applied yet. But then the FFCRA has 1 reason for family medical leave. Now, obviously, FMLA reasons, if you have a serious health condition, all that still applies, and that's a separate bucket, and we won't talk about that on this call. But certainly, if I was eligible, that would be a third analysis that you would have to do. But here, I'm not caring for a child, so that Family Medical Act expansion reason would not apply. Okay. On Michigan EO, what about my Michigan paid leave? Well, if I had paid leave available in my bank that I'm entitled to under state law for paid medical leave, you'd have to pay me for that. Now, if I exhausted that bank, then this leave could be unpaid. How about unemployment benefits? Now, here's an interesting one, because this gets back to an earlier point, is I think you could say that you're not entitled to unemployment. So if I had exhausted all my other paid leave and I was trying to get unemployment, I think you could take the position that Keith shouldn't get it because we have worked for him. He's not coming to work because of this stay home order. That's fine, but I don't think that matches up with the exact reasons in the executive order. Will you win that? I don't know. But I think if you wanted to make the argument that you could do that. So anything on that example, Mary, before I go to the third?
No, I think you hit the highlights.
Okay, great. So example 3, same facts. I get a negative test after 7 days. Whoopee. This is great. And then I'm excited. I want to come back to work. You know why? Because I care about doing a good job. I'm an overachiever, and I want to make some money. I want to make some overtime. And everyone in the plant says, hey, Keith had COVID. You're not bringing him back, are you? If you think you're bringing him back, we're walking out. You see what they did in that Amazon facility in Detroit and Staten Island? You guys bring Keith back, we're walking out. So you decide as an organization, I know I'm embellishing the facts a little, sorry, Mary. You don't want him to come back. What do you do? What are you going to tell him? Do you have to bring him back? This is an interesting one. I don't think you have to bring him back. And certainly, I think you could say, well, we want to make sure, for whatever reasons that you're safe, and so we want you to stay off work for longer, and we don't have work for you. I think you might be able to do that. Now, you might run into some problems with regarded as ADA claim, right? You're regarding me as disabled potentially, but I don't think the executive order gives any protection to my return to work. And certainly I think the documentation there doesn't prohibit you from having a clean return to work. And so I think the right answer to me, and Mary, you can weigh in on this if you feel differently and maybe see other risks here, but to me it's okay, if I had that concern with employees, I'd want a clean bill of health, I'd want to have return to work paperwork. Because I don't think that the executive order precludes employers from asking for return to work paper, because that's not documentation that you have a symptom. That's documentation that you are clear of symptoms. And so I think if you wanted to assure employees' concerns, you say, yeah, Keith had it, but he's all safe now, and we have return to work paperwork that we've got medical verification that he is safe and not contagious, and you can all rest easy. So I do think that's one little wrinkle that's maybe helpful to think about as you bring people back if you run into that situation. Thoughts on that, Mary?
Yeah, so I think this example is a significant judgment call by the employer. So, back in the world that we used to live in, people went to work all the time when their spouse or family member was sick, and, replace the shortness of breath and cough with a headache or something like that. We all went to work when we had family members that were sick at home, but we don't live in the normal world right now. So I think this highlights a significant employee relations issue. So, we don't think it's an adverse employment action if you refuse to let this employee come back to work. This employee is playing amateur doctor, saying that, I'm sure that she's fine. He wants to come back to work, but at what risk? So imagine the scenario where Keith does come back to work, and a week later, his wife's symptoms continue to progress to the point where she gets a test and she tests positive for COVID-19. And so how do we handle that? And think of the reaction of your employees regarding that scenario where we allowed Keith to come back to work when his wife had some symptoms that were related. Now, again, this hypothetical does not have atypical in there, so that there is a judgment call here and perhaps more follow-up here. One thing I do want to note before we go on to the other example is the executive order in itself says an individual that has close contact with somebody that has COVID-19 symptoms who returns to work prior to the period specified, prior to the 14 days that Keith could perhaps be quarantined because he has exposure, is not entitled to any of the protections under the executive order for discharge, discipline, or retaliation. So I think that also would provide some support for the employer if they had Keith sit out for 14 days under this environment.
Yeah, it is some great points, Mary. You're absolutely right. It's a significant judgment call, and something that every employer's got to make sure that they've thought about, and maybe you already have, but if you haven't, think about it from a leadership perspective. How are you going to handle that situation, and how are you going to communicate it to employees? Why don't you go ahead and tackle example 4, and we'll keep moving along here so we can get to some questions as well.
Sounds good. Yep, and we'll go fast forward here in these last 2 examples. So we as employer, we did put Keith off of work. We didn't allow him to come back because of his wife's symptoms. So now Keith has been off of work for 21 days. And you can see through these examples how quickly he's almost been off for a month here. You call him to discuss returning to work, and he states that his elderly mother had a lung transplant several years ago and watches his kids sometimes. With everything that is going on in Michigan, he feels uncomfortable coming to work because he doesn't want his mom to get COVID-19. So we're all sympathetic for Keith. We certainly don't want his mom to get that, but is he entitled to benefits or protection under the laws that we're talking about? FFCRA? We don't think so, because he himself is not exhibiting any symptoms and he's not any of those qualifications for the FFCRA. Same thing with Executive Order 36. There is nothing here. He needs to get back to work on on this. Keith, you have anything regarding that? And we don't believe he'd be entitled to unemployment benefits either if he refuses to come to work.
No, I'm in agreement.
But this is a human struggle for employers, wanting to be sympathetic and not drawing a hard line with Keith, but also not wanting Keith to just stay off work and have other employees follow his lead, and then you're going to be short-staffed. Okay, I think we can get to our final example then, and then get to some Q&A. So what if Keith tells you, same example as the last, but tells you his elderly mother is no longer watching the kids and he needs more time off to care for the kids? Now, this example is could fall under the FFCRA for the Extended Family Medical Leave Act, where a family member needs to stay home to care for their kids, but we would definitely need to know more information. So why is the mother no longer watching the kids? Did she move out of state and it's not related to COVID-19, or has she stopped watching the kids because she's concerned because of COVID-19 that she's vulnerable in her immune system and more susceptible? If the reason why he is needed to care for the kids is related to COVID-19, it's possible for Keith to get paid leave under the FFCRA regarding the Family Medical Leave Act component to that. But the good news is that benefit should be relatively short. We are coming up quickly against the end of a typical school year. Some schools here get out as early as late May. Certainly schools get out in June. And we don't think after the typical school that they would be needed to care for the kids for COVID-19 related matters. This is a typical kids are home for the summer issue that should not apply under the FFCRA. Now, details matter in that. Could we see an argument that says, well, I always had a nanny that came into my home to care for my kids, and she can no longer, or he can no longer do that because of the stay-home orders and the COVID-19, that could be a continuing reason. Other than that, do you have anything more on that hypothetical, Keith?
I do not. Do you want to, should we get to some of these questions in the last few minutes? And I'm happy to stay over a little past 9 to answer some of these questions if you are as well, Mary, but maybe we pick a few of these and we go. This has been a common question or a common variant in the last couple of days for me, and the question is this: does Executive Order 36? Does Executive Order 36 enable an employee to qualify for FFCRA paid sick leave if they were furloughed prior to April 1st due to the stay-at-home requirement? And so let me answer it this way. If the need for leave and these furloughs occurred before 4/1, and I think what maybe the question is referring to is the shutdown order, which is Executive Order 21. If you laid people off or you didn't work for them because of economic conditions, because your customer orders dried up or whatever it may be, and you laid them off, they are not entitled to FFCRA, because even though they may be able to claim that that's an isolation order, that isolation order is not directly causing the person to stay at home. What's causing the person to be at home is the lack of work due to business conditions. And so, and certainly if they're laid off prior to April 1st, they wouldn't be eligible. But even if you lay them off or you're working half your workforce, after April 1st, if the reason that half your workers are off is because of business conditions and lack of work, even though they're subject to a shutdown quarantine order, that's not sufficient to trigger FFCRA benefits. But in the Executive Order 36 context, where that executive order, that stay at home, is now personal to me, right? It's personal to me in the sense that I've individually been impacted, have symptoms, or I'm in close contact, then you would. And so I think that's an important distinction, and that's a very good question. So I wanted to answer that.
All right, we have another question here. Go ahead, Keith. Were you?
No, go ahead.
Okay. If an employee's wife had COVID-19 symptoms and both the employee and his wife were directed to self-quarantine by a healthcare professional for 14 days, but under the Executive Order 36, the employee should stay out for 14 days after the wife's symptoms subsides, which is longer than 14 days than the healthcare provider directed. Which does the employer have to require the employee to follow? Again, under Executive Order 36, it's employee driven. And so if the employee states, and this is not assuming they haven't been tested for COVID-19 and received a negative, that employee would still be allowed to quarantine and stay home himself if it's longer than to match the 14 days after his wife last symptoms. So absolutely, your employee could stay longer than what the doctor initially directed.
Okay. Here's another one. Somebody asked for clarification in what situations an employer can ask for supporting documentation, example, doctor's note, when requesting time off due to a COVID reason. So let me start by saying if the employee, and Mary's right, this is employee driven. So first, if the employee comes to you and says, I want to take paid sick leave, and that is going to be sought under the FFCRA, then you can request all of the information necessary to document and prove the need for that federal leave. Okay, there is no restriction. The EO doesn't restrict what you can ask for for approving federal leave. Now that gets a little bit more complicated because the DOL regulations under the FFCRA, there's one reading that would suggest that you're limited in what you can ask for from the employee, and then there's another reading, and I can talk with anyone that wants to after this. There's another reading that says you can be more aggressive and demand a lot more documentation, but you can certainly request some information and documentation. And as long as you're doing that consistent with federal law, you can do that. If they need leave under the FFCRA, you can get your documentation. Same thing for FMLA. Whatever, if they're applying for FMLA, you can require the documentation consistent with that federal law. If they are requesting the leave for paid medical leave under the state law, so I'm off for one of these EO 36 reasons and I want documentation, you cannot, the one thing you cannot ask for is documentation to confirm the symptoms. So in that case, if it's state-related leave, for that reason, you should not ask, because you could ask, but you could never not grant the leave or not grant paid leave because they didn't give it to you. So it would be a fruitless exercise. So I think to answer the question, it depends on the reason that they're requesting leave. And you may have to clarify that with employees, right? Because employees don't know, right? They say, I just want leave. Well, you have to say, are you requesting it under the, FFCRA, which you may want them to do, right? Because if you do it that way, then you get the quarterly tax credit if you're covered. So you may want to do that, and you want to make sure that you have the right forms. If you haven't got those already from Miller Johnson, we can get them to you to make that happen. Any thoughts on that, Mary?
No, I think that you hit that. One question that we get routinely, and Keith, I'm interested in your thoughts on this as well, is under the FFCRA, what if we're an employer that's under 50 employees? we're not automatically exempt because we don't have the 500 or more employees that are automatically exempt, but what if 50 employees were provided, that we don't necessarily have to follow the FFCRA if it's providing hardship. So the DOL has come out, I believe, strong in that area, that it's going to be very narrowly construed, and they're expecting employers with 50 or less employees to comply with the FFCRA, except under highly unusual circumstances. What are your thoughts on that, Keith?
Yeah, I mean, I guess I'm suggesting until you know you're not covered, I'm suggesting you operate as if you are, right? I mean, isn't that
Yep.
Do you disagree with that, Mary, or are you seeing clients take different positions on that?
No, I have been doing that as, the last thing you want to argue with the DOL is that there's a hardship in having them turn over all of your financials, that you somehow couldn't afford a 10-day leave of absence here. So unless there is something that's critical and there's something that's overwhelmingly undisputable that you could not provide that leave, you should read the FFCRA as not even having that 50 employee exception.
Yeah,
I think that's the best way to go about.
Absent compelling circumstances, I'm suggesting you comply. That's my take on that.
Yep.
Okay, here's one. If an employee enters unpaid leave, is there a requirement to maintain health insurance? So if they are on a paid sick leave under the FFCRA, we know from the Department of Labor regulations last week that they would be entitled to health insurance. But what about if it's an unpaid leave? Then I think, and Mary, you can jump in here if you view this differently, but I think on an unpaid leave status, you would need to follow your practice and policy, right? And make sure that it is done consistently. And so if other employees were on unpaid leave and had their health insurance continued, you couldn't not continue it for a person who is on an executive order 36 stay home type of leave. I think you would run afoul of the retaliation discrimination protections in the new executive order. And then I also think just practically you need to think about what message that sends, if you're going to cut off health insurance with someone who is staying at home because they either have symptoms, tested positive, or a family member or someone in close contact does, that may be the time when they need it the most. So from an employee engagement perspective, I'm not sure that makes a lot of sense unless you're sure that this person is a games player. But do you have thoughts on that, Mary, on the insurance piece?
Yeah, so the only thing I would add to that of what Keith was saying is most health insurance plans allow employers to maintain health insurance for employees that are on a leave of absence up to 90 days. They usually coordinate that with the good old FMLA that we all know and are used to. So we'll want to make sure that we look at our health plan, but to Keith's point, for an employee relations standpoint, what kind of message are you receiving? And you'll want to keep in the back of your mind, especially for those that are in group 1 that are taking leave of absence because they themselves are suffering from COVID-19. That could be a plain old serious health condition under the FMLA. And so in those instances, you cannot stop health insurance.
Okay, we've got a few more minutes. Maybe go to 9:15 here. If maybe we do one or two more, and then we'll try to wrap up here so that we can be respectful of everyone's time.
So a question that we have been getting that I see on here, Keith, too, is wouldn't the employee be better off filing for unemployment rather than FFCRA in order to get more money? So UI benefits will still ask you if you have access to paid time off. And so you will be required to offer FFCRA before allowing an employee to collect unemployment there. And FFCRA is very specific that in the context of other paid leave that employees aren't forced to take that other paid leave, and I think that would also apply to unemployment as well. So apply FFCRA first, and then if they go on and their leave is required in addition to the FFCRA paid leave, then they could perhaps, under certain circumstances, collect unemployment.
Yeah. And maybe one final question here. And I think we touched on this a little bit, but I'll give you my thoughts, and Mary, you can weigh in. But for the safety of team members or employees, can we require a medical release before we permit someone to return if they are self-diagnosed or diagnosed with symptoms or they test positive for COVID? So that goes to my example where, okay, we've got employees that are maybe concerned. They heard Keith was positive or he had symptoms. Can we require a medical release before allowing Keith to return to work? And I think that you can to ensure that safety. Certainly if there's self-diagnosis or the symptoms, you can require some sort of return to work, just like you would for, you could for someone that had some other contagious illness, right? I mean, if I had the flu, you wouldn't want me coming in and contaminating the whole entire workforce. And to the extent you require return to work for other things, I think you can continue to do that. And obviously a negative test, that's great. They probably want to show you that too as well. But do you have thoughts on that, Mary, and what you've been counseling clients on?
Yeah, I think with all of these situations, the specific circumstance and facts matter. And so I would just encourage you, if you are thinking of having these return to works, just seek counsel with your lawyer first and get a game plan that's best for your organization and circumstances, and then go from there. The last thing, Keith, before we end here is getting a lot of questions about when will this Executive Order 36 expire? Great questions, because we have seen typically with previous executive orders, especially the shelter in place, that soon to expire here in short order unless, as we all predict, that's going to be extended. This particular Executive Order 36 does not have a specific end date. It will end when the end of the emergency and disaster, the state of emergency and disaster. So we all know that has been extended by our government, and that was yesterday, I believe, for an additional, what was that, Keith? Month, essentially?
Yes, through April 30th.
Yep. And so right now, this executive order would end April 30th, but I suspect that may get extended beyond April 30th for our state of emergency as well. So great question. This is going to be indefinite until we get the state of emergency passed.
Yeah, and to follow up on that, we can expect some additional executive orders in the next few days now that extension has been granted, because remember the shutdown, which, restricts all but essential operations and business operations in the state, that's scheduled to expire April 13th. But now that the emergency has been extended, that'll give the governor authority to extend that further. And certainly that's going to likely be extended here until the end of the month. So you will likely see a bunch of executive orders. If you haven't gotten enough already, you'll get some more, and you'll get some notices, I'm sure, from Miller Johnson. But with that, I want to thank you all for participating, or listening in, I should say, and participating through your questions. Sorry we couldn't get to all of them, but certainly Mary and I are available if you want to give either one of us a call or reach out to the Miller Johnson team, and we can get answers to your questions. And just a reminder, tomorrow we have a webinar on the CARES Act and its implication for healthcare employers. So hopefully, if you're interested in that, you can jump online tomorrow morning. And again, I just say thank you, appreciate your time, and hopefully we've been somewhat valuable and a resource to you.
All right, thank you.